taking of the court file 015 from Kirinyaga Court in the middle of the night was a gross irregularity that impacts on a fair trial. The bringing of that file in the middle of the night from Kerugoya, presumably the Deputy Chief Justice, was another gross irregularity. For the Deputy Chief Justice to have sat in the middle of the night on Friday, the 18th of October, was a gross irregularity. The absence of communication from the Office of the Deputy Chief Justice to the parties in 015 was a gross irregularity. For your lordships and your leadership to have sat as a court outside the prescribed court days on a Saturday was a gross irregularity. The maxim that justice must not only be done, it must manifestly be seen to be done, is an extension of the right to a fair trial guaranteed in Article 50. This litany of irregularities contaminates the sitting of this bench irredeemable. Now I would ask that in respect to Article 50, we do not even go into issues of recusal. Your lordship, your leadership should, on the basis of those irregularities. Now, there is one I have forgotten. When this honorable bench was hearing our plea for an early date, this honorable bench said the earliest date they had was Thursday of this week. So now, with this litany of irregularity, this honorable bench found time to give a hearing today when they say they are only available. Let justice be seen to be done. The only urgency that one is able to trace is that somebody somewhere is in a hurry to vacate the conservatory orders that preserve the substrata of the petition was very weighty issue in order to swear in somebody somewhere. Yes, you are concerned with the Constitution. Permit me to point out with a lot of respect, my Lord, to your leadership. I have gone through these things during the radical surgery, and I doubt that we have seen the last of the radical surgery. And my plea is that you preserve constitutionalism, you preserve the dignity of this court, because the people of Kenya are looking up to the judiciary. Only preserve that.
May it please you, presiding judge and members of your court, we thank you for the opportunity to reply as respondents. Before I do that, I want to thank
to find out whether we are with the for Muite or not. Yes, how many people are supporting the application?
In number 15.
Are you parties in this matter?
Yes, we are consolidated. So there's a petitioner, the second petitioner, who has.
For the second petitioner, with the support of the application side, this is Kemoto Teresia Wanjiro from Test Kemoto and Company Advocates. For the second petitioner. Yes. So perhaps I'm also allowed to submit or go to. Okay, thank you. So, Your Honor, I'm in support of the application. The fact of the matter and why we are in support of it is, number one, as I said earlier, we were never served with those directions. And the fact that we were never served, this is proper procedure. That's any matter that is taken before a judge. All parties must be notified. We were never notified. So why we were never notified, and I had to learn about this issue today, I do not know. That raises eyebrows. And from the petitioner's side of view is, will this bench be impartial? Or we will be hard? Because if directions are being taken, petition E013 of 2024 is part and parcel. In fact, it was consolidated. We have not been notified. Why? Number two, the issue of fair hearing, Article 50, has been repeated over and over again. Isn't this a violation of the second petitioner's right to fair hearing? In fact, some of these applications, I'm getting them now. Yet, I should have been served before. Why the hurry? Why the rush? Why am I supposed to be served right now in court and I'm told 5 minutes submit? What is in stake? Let us all get a fair hearing. And with these preliminaries that are coming up, one is meant to wonder, will we really get justice? Petition E013 2024 was filed before petition E014 and E015.
Council, just for your information, those were your orders you got from Gregoria, where the petitions were consolidated. So that must have been your application before that court.
Yes.
So don't bring it here.
Yes. But the issue is, even after it was brought here, it is being mentioned and we are not aware. So if a matter is going to be mentioned and we are not aware, then it only shows either the bench is ignoring us, or perhaps our petition has no merit, and why so, yet we have not submitted. Let us be given a chance, let us be given audience, even to reply to the issues that are being brought forward. And we cannot reply when standing right now. I need time, I need 1 hour or 30 minutes or whatever, but I need time. So those are the issues why we are in support of this application. We feel that we are not being given a fair hearing. And the other issue that has been raised also, that the bench sat on a Saturday. We are not aware, we are learning right now. We know court operates Mondays to Friday, 8 a.m. to 5 p.m. This Saturday, when was this direction issued? Why were we not informed? So those are the bases why we are now joining hands. Though our petition has its own grounds, but then again, because of those issues, we feel if we don't raise these issues, then we might not get proper justice, because there are some people who, of course, are SDAs who are not able to sit on Saturday, who are not notified again, you know, those kind of issues. That's why we are wondering why the rush. Yes, maybe.
Yeah, on the application for empanelment.
Yes. Yes, yes. That is the issue. The issue was that, and I've also talked about it, we were never informed. And any petition, any case that will be given direction, so long as I'm late, so long as there's a petitioner there, I have to be heard. And that is the law. And there's nothing new I'm saying. This is the procedure all advocates use. Why is it that I'm being ignored? I'm being notified 11 a.m. watching television, and I was very eager like any normal Kenyan. I see my petition being mentioned. I was very angry, but I decided to take a vehicle from Kirinyaga County quickly to come before this court and inform the court that that is not fair. That is not fair, and Article 50 has been violated. And this being a constitutional court, kindly allow us to participate fair.
Yes, yes.
Your Lordship, in the limited time that you start to prepare, your name please, my name is Kirabu Abita. Within the limited time that we start with my learned friend, Mrs. Kimova, and despite all those challenges, we have come up with about 4 points which we request that we be allowed to submit on, since we do not have more time to file documents in support of the application. So kindly, my Lord, give me 5 minutes. Your Lordship, the powers that are given to the Chief Justice to empanel a bench, as submitted by my learned friends, is not a power that can be delegated. In constitutional classes, which we have the privilege to be tutored by Senior Counsel, Professor Gideon Muigai. He told us that there is a principle called delegatus non potest delegare. A delegate cannot delegate. So that the people of Kenya have delegated power to the Chief Justice to exercise that power. And the Constitution does not leave any room for delegation of that power. So now, we are before you, having been empaneled by a person who does not enjoy the people's power to empanel a bench. Well, Lord, this is a jurisdictional question rather than an administrative question. And from the decisions which have been cited by my learned friends, Kemri, Okiom Tata, and the Conchella case, one thing you learn is that in Kemri and Okiom Tata, the court said this is a constitutional function and it cannot be delegated. When you go to the Conchella case, the court allowed or said that the Deputy Chief Justice could empanel a bench. Again, it went ahead and gave some conditions. I don't want to go through all that. But Your Lordship, what you learn again is that shortly after the Conchella decision was made, an appeal was filed in the Court of Appeal. And who filed the appeal? It is the National Assembly who is a respondent today. It is the Senate, again, who is a respondent today, urging you to take a contrary position. What was the argument by the National Assembly and the Senate before the Court of Appeal? The argument was the Deputy Chief Justice cannot perform this function. And on the basis of that, kindly stay the proceedings before the High Court. I'm referring to Nairobi Court of Appeal, civil application, number E097 of 2021. So the Senate and the National Assembly went and argued before the Court of Appeal. Don't allow those proceedings to go on before the High Court, because that bench, a 5-judge bench, is appointed by a person who does not have the authority to appoint. And the Court of Appeal considered that application. In the ruling, the court agreed with the National Assembly and the Senate. And the ruling does not have a paragraph numbers, but towards the end, now in finding that the Senate and the National Assembly had an arguable case, they said, as we have observed, an arguable point of appeal is not one that will ultimately succeed. The point intended to be argued, whether the Chief Justice was empowered by the said article, the article we are discussing, to empanel a bench of the High Court, is not an idle one. It's not an idle point. It is an arguable point. The court, on the nugatory aspect, stated that on the nugatory aspect, it appears to us that if it was to be held on appeal, that the Deputy Chief Justice had no power to empanel the bench, the appeal would be a victory with no practical effect and academic exercise. So, the court also considered the third aspect, which was introduced by the Supreme Court in a previous decision, the public interest consideration. They said, we find also that this is a matter in the public interest domain, and it is proper that the appellant exhaust the appellant's rights. So the court went ahead and said that the motion succeeds and stayed the proceedings in the High Court, and to date, they stayed. And the appeal was supposed to be determined in a certain period of time. The appeal is still pending, and the proceedings in the High Court are still stayed. So, my Lord, you are at the place where the 5-judge bench found itself. It made a determination, it was stayed. So today, we do not have any decision where the empanelment by the Deputy Chief Justice stands. Therefore, before we proceed in these matters, kindly find that the Deputy Chief Justice does not have power to empanel a bench of an even number of judges to do that. Thank you very much.
Your Lordship and my lady, within my place, my name is Akimpa. I act for the third petition in this consolidated petition, which was Kerugoya E014 of 2024. Your Lordship, I want to begin to say that the proceedings that are before this court today are fruits of a poisonous tree for the following reasons, my Lord. The first reason is that, Your Lordship, our matter was referred to the Honorable Lady Justice, the Chief Justice, on 11th of October 2024 for empanelment of a bench Your Lordship, the same has never happened until the conservatory orders in petition E015 were granted. It therefore shows Your Lordship that petition E014 as consolidated with E013 are here to seal the loopholes so that we cannot question why petition E015 was brought before this court before E014. Your Lordship, I just want to agree with all the submissions by my learned friend. That is my submission.
Speaker, can I address? I don't hearing of matters during night hours. The answer to respectfully, my lord, but judges can hear matters at all hours. I have done so. The colonial judges had cases at odd hours in the middle of the night, early hours of the morning. I remember appearing before Judges, Chief Justice Simpson, these would be cases with simple matters, like individuals who want to bail at night because profits have been in the bar, they have drunk a lot and they want to bail. You rush from the judge's home or the chief justice's home and you would grant bail. It's a beautiful custom, beautiful practice, and I invite you to respectfully, my lords, that you endorse it in your ruling. It gave justice to people. It was a good practice. Instances like in Mombasa, Your Honor, you would have foreigners who have had children, are still minors in the world, our local girls, and you want now to fly out with these little children at odd hours. They want to get to work, they want to get to the ships at odd hours, and you rush to a judge at night and he will give you an order and you go and stop it. During those days, Your Honor, something that I don't see these days, I wish it could be reinstated. You would have names of the judges in publications, like telephone directories, their telephone numbers would be there. You would know where they live. You would rush to a judge's home because you know where he lives and so on, and he would grant you orders. We no longer have that type of thing at all. I wish it could be reinstated. It was helpful. It handed down justice to the court. I recall one judge I appeared before, and I think he had me talking to his askaris at night. And he came out, shouted, "Who is that?" Somebody said, "Oh, it's Khalilma. He wants to come and be heard." And they shouted at me and said, "Khalilma, I want you to know I'm not a judge during the day. I can't hear you, the time is over." And I returned and told him, "Judge, the world is shocked to hear, or the country is shocked to hear. You are only a judge during the day, and at night you are not a judge." My Lord, let us reinstate that practice. Say so very loudly in the ruling. But then, coming to in some case, what has happened is completely wrong. Your Honor, the Deputy Chief Justice, his powers are set out in Articles 147, 148, 149, 150, 141. He has enormous powers. If a person can become a president of the Republic at any time. If you're going to hear his matter regarding impeachment, you should hear it during the day and it should be heard in the parties. It's not a matter that can be heard at all. what the Deputy Chief Justice or whoever it is would have done is to get on phone, get in touch with the attorney general, get in touch even with the advocates, and ask them, can you come? But you should not have had this matter experted. This is not a matter that you had experted at all. And then also, when you look at the constitution, the constitution seems to be very clear. I will refer you to Article 165 of Article 4. 165 of Article 4. If you permit me just to read it in the court. It says that, not 165, Article 144, sub Article 4, Article 144, sub Article 4. It says that 144, sub Article 4. So first, yeah, if you look at that 144 of Article 4, if you can get 144. Yeah, thank you very much. If the Chief Justice is unable to appoint a tribunal under Clause 3, the Deputy Chief Justice shall appoint such a tribunal. So you see very clearly on where the Deputy Chief Justice can act is set out in the Constitution very clearly. Now, in this particular case, it is not set out in the Constitution regarding impeachment. It does not confer power on the Deputy Chief Justice at all. If I may also refer your Lordship to impeachment provisions relating to the Deputy Chief Justice, Article 144, Article 145, Article 150, Article 1B. Those provisions are expressed. Now, the next thing I may wish to deal with is if you could look at Article 165, Article 4, 165, Article 4. 165, Article 4. It says that any matter certified by the court as raising a substantial question of law under Clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the Chief Justice. Now, before the Chief Justice appoints the Chief Justice, he takes into account a number of things, my friends. He will take into account the experience of the judge that he is appointing. He will take into account things like whether it would probably bring a conflict of interest. He will take into account whether there would be objections from certain individuals and so on, when not to do that at all. It takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated. The Deputy Chief Justice at all. It is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the registrar from getting in touch with him and explaining to her that, look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And they would probably say that, look, why don't you have so and so, so and so, so and so, so and so? And you would actually assign the judges to hear such matters. I would emphasize, and I also keep myself with my own friends, that there has to be miscarriage of justice. the Deputy Chief Justice should not have done what he did at home. Not that you have got anything against her, not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind in law, the issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people calling together? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. They may come to a conclusion that look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are dealing with matters to do with the administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the Deputy Chief Justice was probably preferred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their first kind dealings that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the executive and such things are so. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submissions of my able-learned friends. There is a word somewhere, I think in the Constitution, that the Deputy Chief Justice may perform functions today or the duties of the Chief Justice in absence. Clearly, that refers to cases where the Chief Justice may be relieved or the Chief Justice may be sick or the Chief Justice may be involved in something that is cannot enable to perform the work and so on. Now, in this particular case, nobody has alleged to the Chief Justice for anywhere. Nobody has alleged to the Chief Justice on duty. And nobody was alleged anything that made it impossible for the Chief Justice to carry out her duties at all. Again, I emphasize the first down on removal of the Deputy President as Dr. And it's something that is making a number of Kenyans entertain us for interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current country. Now, you can't blame her when such things were happening. You can't blame her to have come to the conclusion that the Almighty God and the Lord Jesus Christ no longer support the current government because of such things as well. I ask you very strictly that you have full submission of my young friend, Mr. Kigwe, and his care colleagues. They are able to submission, and it is unbelievable. Thank you.
May it please the court. We will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law.
Yes.
Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we